morning, everyone. Welcome to the First District Court of Appeals. We have today 4 cases up for argument. I'm going to go through the cases, and if the attorneys would please stand up and state your name and your readiness to proceed when I call the case. The first case up today is In Re E.H., case number C220079. Morning.
James Moskowitz for appellate, ready to proceed.
Good morning. The next case up for argument is Harmon versus City of Cincinnati, case number C220236.
Lauren Credit Mike, the appellant, ready to proceed.
Bob Stokar for Mr. Harmon, Mr. President, I'm ready.
Thank you. Next, we have U.S. Bank versus Ty, case number C220071.
Your Honor, William Behrens for the appellants, they're ready to proceed.
And Matt Richardson for the appellate, ready to proceed.
Good morning. And the last case is State of Ohio versus Prather. It's C210585.
David Hoffman for the appellant, Your Honor, ready to proceed.
Sean Donovan on behalf of the state, Your Honor, ready to proceed.
Good morning. All right, if the attorneys for In Re E.H. would please come up to the podium, or the council table. Ms. Adams, how much time would you like to have for rebuttal? 5 minutes, okay. I'll be keeping your time. I'll use the lights that will be at the podium. When you have a minute left, the yellow light will come on, and the red light means you're out of time. So whenever you're ready.
Good morning. This is a custody case involving E.H. Just for purposes of today's argument, I'm going to refer to the parties by their role rather than their names. I represent the appellant mother, the father, Joseph Kehoe, the child, E.H., and the guardian ad litem. This case began with an agreed entry, which was the initial custody determination in 2010. The parties agreed at that time that mother, who was already the default custodian for the child as she was born to parents out of wedlock, would then be designated the residential parent and legal custodian. The terms of that agreed entry were laid out. They included some parenting time. There was a discussion of certain milestones that father had to meet in order to expand his parenting time. And the agreed entry also referred to the continuing jurisdiction of the court pursuant to Ohio Revised Code 3109.04, custody, and 3109.051, parenting time. Flash forward 11 years, there's been continuing litigation between the parties, but the most recent pleading filed was a complaint for custody filed by father. The litigation went on for years. There was a series of hearings over several days that were continued in progress. When the magistrate presiding over the case issued her decision, she erroneously cited the standard in 3109.04F, which is an initial determination of custody to be decided under the best interest legal standard. Unfortunately, because of the prior agreed entry, in 2010, this case should have been decided under 3109.04E, which is the modification of custody standard. The legislature of the state of Ohio...
Right, but the problem is no one raised that to the court's attention, right?
Could you clarify your question? Are you saying no one raised that to the magistrate's attention in the most recent litigation?
Yeah, was there an objection to the magistrate's use of the best interest standard rather than change of circumstances?
After that decision was issued in July of 2021, no, that issue was not raised. There is I believe, a one-line reference in the objection filed by mother. It was a previous attorney. I wasn't handling the case at the time. That refers to the fact that there's been no weighing of the detrimental effect for the child and the change of custody. But no, there's no specific objection relating to the standard. However, I would point out that this matter is under de novo review because the court is considering whether the magistrate incorrectly applied the law to the case. And it's clear from the face of the magistrate's decision that she used the erroneous standard.
But how is it de novo review if there's a failure to object?
Because it constitutes plain error.
But then it has to meet the plain error standard, right?
I believe when I reviewed the cases in Re AG, which is out of the 8th District Court of Appeal, they've specifically looked at a case with similar facts and determined that a failure to make the findings required by 3109.04E constitutes plain error.
And so even though this issue wasn't framed on the objections, weren't there sufficient findings in the magistrate's decision that would be applicable to change of circumstances, even though the magistrate didn't label it like that?
I think that's absolutely, you've struck to the heart of what this case is. I think you're going to hear some argument from appellee's counsel that that is the case, kind of a, to use a sports reference, no harm, no foul kind of argument, and I'm going to say no. First of all, this decision on its face cites the wrong legal standard. We can't let that stand. I mean, it completely eviscerates the whole point of 3109.04E, which is that there is a certain public interest in giving stability and continuity to children. Once that initial custody determination is made, the status quo should be maintained. It creates a presumption that the status quo is good for the child, is in the child's best interest because of this feeling that a child's mental and emotional development, it benefits from continuity.
But
So-
doesn't the case law allow us, if we can, to infer change of circumstances from the record, though?
Yes,
Okay.
it does.
So
And
the-
I'm not
the-
arguing against that.
Okay.
And I think in a case
And
where.
you're just saying that we can't do that based on this record?
I'm saying, first of all, if that would apply to a case where the standard wasn't specifically stated, if there's nothing in the decision which indicates whether the magistrate or the judge used the best interest standard or the change of circumstances threshold standard, then you could infer from the language of the decision that the court found or made the requisite finding of a change of circumstances. Here you have the court specifically stating they used the wrong standard. So first of all, I think that's a hard line.
So because it sounds like the court didn't realize that there was this prior order granting custody, right?
Because I came late to this case, I reviewed the entire record. There are previous hearings where the court notes that it is a modification and a change of custody case. So I cannot explain why, although in the transcript, the magistrate notes it's a modification, why in the final decision she uses the wrong standard, but she does, in her analysis, state that she felt because the 2010 action, the agreed entry was the result of father's complaint for visitation and not complaint for custody, that for her, that was dispositive, but she disregarded the language of the actual court order.
Going back to my initial question, in the briefing before the magistrate, when both parties were setting forth their positions, were there arguments made that the change of circumstances standard was the applicable one? Did the parties argue it within those confines?
I can't definitively
I mean,
answer that question.
I guess, like, the problem that I'm seeing is I hear what you're saying on the statutory disconnect, but if the parties don't raise this to the court's attention and multiple opportunities to do so, I'm not sure what we're supposed to do with that.
Well, I think the court's required to apply the correct legal standard, whether the parties argue that or not. And in a case where the court cites the incorrect legal standard, it is up to the appellate court to remand for an analysis under the proper standard. And very briefly.
Isn't the trial court able to correct an error that's on its face of a magistrate decision even where objections aren't filed?
Could you repeat that question?
Isn't a trial judge, in reviewing a magistrate's order, able to correct sua sponte a magistrate's decision, an error that's clear on its face, regardless of whether objections are filed?
In this particular case, when the judge reviewed the magistrate's...
That's not what this case is, but I'm saying that even where objections aren't filed,
Okay,
and I can't remember the rule, to be able to cite the rule.
okay. I don't know. I do want to address very briefly this no harm, no foul argument. This, to me, is what this case is really about. If there were no language using the incorrect legal standard, and there had been a proper investigation by the GAL into whether there was a change of circumstance, and the magistrate, 2 steps there, GAL proper investigation and magistrate making findings regarding a change of circumstance, then even if the magistrate didn't cite the express language of the statute, I believe it would fall into that category of cases that Your Honor is asking about. But in this particular case, if you look at the record as a whole, the child was reporting things to the guardian ad litem, and I'm going to give you a few examples. She was reporting a high level of anxiety. She was reporting that mother had some physical health problems that impacted her ability to take care of her children. She was reporting like multiple dogs in the home. These are all things that if the guardian ad litem had investigated them appropriately could obviously have been considered a change of circumstances. The breakdown happens because the guardian ad litem treats the case as if it's under the best interest statute. The guardian ad litem never interviews the child in the mother's home with the mother present. So, I mean, this is classic in a custody case that you potentially could have a child that reports one thing at father's home when the GAL is interviewing the child with father, and then changes and gives completely inconsistent interviews when in the mother's care, because that's what happens in custody cases. Children want to please, and they may change their story based on the party that they're with. That's one of the reasons the guardian ad litem is required to interview the child at both parents' home. The guardian ad litem in this case didn't do it, and she didn't do it in the most important setting, which was go into mother's home, see whether there are dogs in the house. But again, there's 2 prongs to that. Are there dogs in the house now? Were there dogs in the house in 2010? If there were 1,500 dogs in the house in 2010, and there's 1,500 dogs in the house now, then it's irrelevant to whether there's a change of circumstances. That's only a best interest analysis. And so the breakdown happens because the guardian ad litem doesn't investigate whether there's been a change of circumstances. There's only one reference in the guardian ad litem's report in the magistrate's decision to the child's educational placement. And that apparently was very positive information. The child did well in her placement at Sycamore Schools. She had been in the Sycamore Schools her entire life. There's no discussion of if a child has anxiety, will a change in a school placement at this particular age have a detrimental effect on the child? There's nothing to indicate that either the guardian ad litem or the court made this requisite weighing of the detriment versus the benefit, the loss of the stability, the change in the status quo. And that's what I think this case is really about, and that's why this court needs to reverse this decision and remand.
Thank you. Ms. Adams, you did go a little over your initial, so you'll have a little over 3 minutes
Thank
for
you.
rebuttal.
Good morning, Your Honors. There seems to be some confusion about what we're doing here. So I want to start with first, what order are we reviewing? We are not reviewing the magistrate's decision. We are reviewing the judicial entry that was issued as a result of objections. So it doesn't really matter what's in the magistrate's decision. The focus is on what's in the judicial entry.
Did the trial judge use the right standard?
So the judicial entry says that she performed an independent review.
Okay.
And she doesn't say what standard is used.
She doesn't
So
cite the statute.
Correct. Unlike the magistrate's decision, which admittedly did say that she was using the best interest standard. The judge didn't specifically say what she was doing. So then, as I argued in my.
Doesn't the court have to do that? I mean, like,
don't
you
think
can't.
so.
Do you think if the court's entry said, I've reviewed the magistrate's decision, independent review, it's all correct, and therefore, here's my decision, with no analysis, no explanation of what the standard is that sufficient for our purposes?
I think so. I don't think that it's mandatory that the court uses special words and waves its hand and says, this is what I did. The presumption is always that the court acted correctly. That's the legal presumption that this court has to use.
So a court never has to say what statute it's looking at or standard it's using, is what you're saying, as
I don't-
long as, we'll just presume they did it correct.
In this context, no. I don't want to make a blatant statement.
Okay.
There could be laws that require something.
In a custody context, you're saying?
I don't think that they're required to spell it out. I do think that the case law that's evolved on the issue says that if the record supports the ultimate finding that there's been a change of circumstances and the order's in the best interest, that's enough. That's what I think Your Honor raised initially when counsel was arguing. So in
So
this.
what do we do with the language, because I'm looking at this as you're making your argument, with regard to the objections, the trial court concludes, for all the reasons discussed above in determining child's best interest, and primarily due to the anxiety child has regarding mother, the court finds the parenting time schedule set forth by the magistrate is appropriate and in the best interest of the child.
Can you tell
So
me
at
where
that
you're
point,
looking?
there's two parts that I'm focusing on. Is first, I mean, that ultimately the trial, this is page, let's see, page 4, and it's towards the bottom, it's second to last paragraph. Ultimately, the trial court is focusing in on best interest and a review of the magistrate's determination of best interest. So as I'm going through this, I don't see that the trial court articulates anything beyond best interest.
Well, as I said, the court did not use the magic words. You're exactly right. They did not put in there, I find there's been a change of circumstances. I don't think that it has to do that.
We
And
have a magistrate decision that specifically articulates the wrong statutory section. Then we have a judicial entry that is silent, but only articulates a best interest discussion.
Well, I don't
So
think
are you-
that's what it does. I think this record is replete with facts that support both a best interest finding and a change of circumstance finding.
But I
So
think
disagree
the
with
issue
that.
before us is can we review a decision that is devoid of, or more importantly, that specifically announces that it's using a statute that doesn't apply?
I don't
So
think, that-
regardless of the facts of the case, can we review that?
I don't think that's what, again, you're relying on the magistrate's decision. I'm relying on the judge's decision. The judge's decision does not say what you're saying. The judge's decision says for the
judge's
foregoing.
Pardon me, the judge's decision says exactly what I said it says, which it says best interest and doesn't go beyond that.
It didn't say that it was using a best interest standard. It found that the change was in the best interest, which is one of the findings it has to make. That's what I was about to read. For the foregoing reasons, which this is after listing out all the different reasons that support both change of
If
circumstances
you can
and best
direct me
interest.
to where you're reading.
Yeah,
I would
it's
appreciate
page
that.
4,
Page 4, okay.
about 3/4 of the way down,
Okay.
right after father relocated to northern Kentucky. It
Okay.
says, for the foregoing reasons, the court finds an award of legal custody of the child to fathers in the best interest of the child. Therefore, the court finds the magistrate did not err. That phrase is not saying what I think you were implicating, which is that it used the best interest standard. All that phrase is saying is exactly what the words say. We are finding that the change is in the best interest, which is a required finding. I'm not arguing that the decision is devoid of the words you're looking for, that we're talking about. It is. I'm just saying that case law allows the reviewing court to review the record and say, it's not in there, it's not no harm, no foul. Let me be clear about this. This is not no harm, no foul. This is case law that says this is an appropriate way for it to happen. If the court doesn't specifically say it, but the record supports the finding, it's okay that the magic words aren't there. That's all I'm saying on that issue.
But usually that has to do with the court articulates the correct statute, but then doesn't say, I find a change in circumstances. Right,
Well,
those are the cases
So,
that you're talking about.
you know, if there was, the court's not required to do any of it. So there could have been a follow-up request for further findings of fact, conclusions of law. There could have been objections. There could have been a lot of things. A lot of the actions that weren't taken, I can't remember which one of you brought this up, but it basically took away from the court the ability to correct a potential error.
Well, and
which is what-
that was the thrust of my initial questioning to opposing counsel, which is, clearly it wasn't in the objections, but were there any arguments in the briefing before the magistrate that would have said, hey, the change of circumstances standard applies, and here's how we look at it?
So if you go back and look, and I think counsel pointed this out, the magistrate's decision actually talks about a change in custody. So I don't know why the magistrate put that in there. So if you look at the decision, it's two different things. They're acknowledging we're doing a change of custody, but then said that's the standard. As I said, it went up on review. As far as I'm concerned, once it goes up in the review, the court issues its decision. That's what we're looking at. So, again, I think that
But my
by
question
failing.
is, did the parties frame it with the correct standard at any point in time?
So after this decision was issued, there was nothing before. There would have been no reason before. As I said, the decision itself even acknowledged we were there on a change of custody. So nothing before, and clearly on objections, nothing was raised in the objections. I want to point something else out, and maybe it's my own confusion. The argument about the removal of the guardian ad litem, aside from the fact that there's more evidence that I can even point to show all the work the guardian did, and what the real argument is, was simply mom wasn't happy with the decision. And all of the things that counsel is talking to you about the guardian are really things that you would use on cross-examination. The guardian was very clear in what she did and didn't do. The guardian, despite what counsel said, the guardian did speak to the child at mother's home, but didn't go into mother's home because, as the guardian said in her report, it seemed pretty clear to hear mother didn't want her there or in the home, and seemed, I'm paraphrasing now, kind of annoyed that she was there. This is after months and months and months and months of mother avoiding calls from JFS and from the guardian. So the other thing the guardian pointed out is, yes, she was there at mother's house but didn't go in, but so was a social worker from JFS. And since they were going in and the guardian felt that mother already had an issue with her being there, she allowed JFS to go in, do the evaluation, and then she reviewed everything JFS did. What they want to do is, on the one hand, acknowledge that the rules of superintendents are guidelines to the courts, but on the other hand, argue because this guardian didn't do every single thing in the rules of superintendents, therefore she was deficient. That's simply not the case. And
Really,
as-
I don't know if they're really arguing that. I thought it was, that the argument is that it was so below the standard.
Well, I don't know how that could be. The guardian took action to ascertain what the residences were like, took action to talk to mom and dad, took action to talk to the child, talked to the maternal grandmother, because she was present when the guardian was there, and actually admitted that she spoke to the guardian and they were talking. She contacted the school. There's a complaint that the guardian didn't talk to the therapist of the child, but mom must have forgotten that at the time the guardian was doing her evaluation, there was no therapist because mom wouldn't take the child to a therapist. Dad was asking for it. The guardian was asking for it. Mom simply refused. And once the report came out, lo and behold, the court made an order that required the child to go to therapy. So yeah, the guardian didn't rely on a therapist because there was none.
The argument, as I understood it today, was also that what the guardian in fact did wasn't sufficient to go towards change of circumstances, that there wasn't enough to evaluate there for change of circumstances.
That's the other mistake that I referred to up front. The guardian's role. The guardian is not the trier of fact. The guardian does not make findings of there's been a change of circumstances, there isn't. The guardian's job, and I hope I'm right because I'm a guardian, so I hope I'm doing it right, is to do an investigation and give a recommendation to the court as to what we believe to be in the best interest of the children. We do not make judicial determinations. We are not required, and it is inappropriate. Actually, we cited a case to you that says it's inappropriate for a guardian to make that kind of investigation. We don't determine change of circumstance. We give a recommendation of best interest. That's our role, that's it. The court can take it, the court cannot, but it's the court's role to do all those cool findings that trigger jurisdiction, initiate a change of custody. Did that answer your question?
Well, I understood the argument to be that that there weren't enough facts provided in the guardian ad litem's evaluation or report for lack of taking on certain actions and, for example, entering the home, investigating the dogs, for the trial court to be able to properly weigh the change of circumstances.
So there's 10 pages.
And that was an argument I heard today.
Facts.
I'm not sure I read it in the brief.
Yeah, there's 10 pages. The other thing I wanted to point out, I'm not sure what it is that's being appealed. There was a motion to remove the guardian that was filed March 10th of 21. There was an order that was issued May 25th, 21. The notice of appeal, I'm not seeing references anything other than the final order that determined custody. So I'm not even sure that that issue is properly before the court, unless I'm mistaken about something. I didn't make that connection, and I know the question in your head is probably, why is it in the brief? Well, I had an associate do the brief, and so I'm looking at it now and can't make that connection. Forgive me if I'm mistaken, but I'm not seeing where that was, where there was an objection, a decision, an appeal of that decision. It's not in the final order that's in front of this court. But in just taking a step back, and I don't know where my time is.
You're at 13 minutes.
Okay, thank you. Your Honor, my brief lists out, there's a lot of work that the guardian did. I mean, a lot. And a lot of work that she didn't do and couldn't do. And if you read the transcript and you read kind of the questioning of mom and see how she responds, you'll understand how difficult it is to actually do things. But all of the complaints made, the guardian did. They were complaining the guardian didn't investigate dad and his past history of alcohol issues. Well, the guardian said she did, and the guardian specifically said she asked people close to him, mom, the child, anyone else, about any specific instances that gave rise to concern. Nobody could raise one. She talked to dad. Dad said he wasn't with a therapist anymore. He had not had a drink in 2 years. He was fully employed. He was not having any trouble. She asked him about his history. And from those pieces, Ann saw a 2016 alcohol evaluation that was done for court the last time they were in court. And from all those pieces determined nothing further needed to be done. And I think she specifically said something to the effect that because mom didn't even raise or give me something that would raise questions, nothing further needed to be done. So someone doesn't have to beat a dead horse. If a guardian gets information and makes a determination in good faith, they don't need to do anything further, that's enough. If you don't agree with it and you think they should have done more, you are free to cross-examine them. That was not done. So to come now and somehow say, despite all the things the guardian did, it was wholly inadequate, that's crazy. You see the guardian talks about the child's school. She does talk about home, school, community, relationships with family, with friends. She does it all. Does everything a guardian's supposed to do.
You are at.
Am I out of time?
You are at your time.
Okay. Any other questions? Okay, thank you very much.
Thank you. Ms. Adams, you have about 3.5 minutes.
I'm going to just make 3 quick points, and then if you have any further questions for me, try to answer those. If you look at the specific language of 3109, .04E, it says, "The court shall not modify a prior decree allocating parental rights and responsibilities for the care of the children unless it finds, based on facts that have arisen since the prior decree or that were unknown to the court at the time of the prior decree, that a change has occurred in the circumstances of the child." If you look at the judicial entry, I know you found the language on page 4 significant. I personally find the language at the bottom of page 2 significant. Court goes through a series of facts indicating what the present circumstances are, and then at the bottom of page 2 cites the legal standard. When allocating parental rights and responsibilities, the court must determine what is in the best interest of the child, and then the court cites section 3109.04F. That's the incorrect legal standard. In between, there should be a transition between father's custody and when allocating parental rights and responsibilities, there should be a finding under 3109.04E. That's where the finding should be. It's a threshold. It's a jurisdictional issue. Without it, you cannot make a change of custody. That's my first point. My second point is, opposing counsel mentioned the social worker and the guardian ad litem's reliance on the social worker, and I agree. The guardian, instead of doing her job, relied on the JFS caseworker to go into the house and investigate these things. And interestingly enough, if you review the caseworker's notes, she found the allegations to be not corroborated. So the guardian ad litem's conclusion was not consistent with the person that she relied on to do the GAL's job.
What wasn't part of the problem was that the mother was being uncooperative with the guardian?
I think that there was noise regarding that, but I think the caseworker's conclusions about that were very different than the guardian ad litem's. And I think, you in order to reach a conclusion about that, you would have to read in depth all of the record relating to the testimony from both of those witnesses. Finally, I would also comment that all of the guardian ad litem's report that focused on Dad, and hey, kudos to him. He changed his life. He got a great job. He apparently solved his substance abuse issues. He solved maybe his mental health issues and medication was no longer necessary, but it doesn't matter. He's not the relevant person. Whatever his change of circumstances are, they're not relevant because the statute doesn't address a change of circumstances in the non-residential parent. It requires a change of circumstances with the residential parent or the child. That's mother and child. So all of the time that the GAL spent investigating father's change of circumstances and his substance abuse assessment and speaking to the child with father.
But I think that's kind of, it gets back to the facts on the record and the anxiety of the child that is provoked by mother seems to be a pretty significant change in circumstance.
I would agree with everything you said, except that I think you have to have an investigation into what the cause of the anxiety was. Was the anxiety provoked by mother, or was the anxiety a result of a prolonged, decade-long custody battle between two parents that the child had loyalty to? There's absolutely no investigation into that. That's unacceptable.
You are at your time.
Thank you.
Thank you. Thank you both for your arguments today. We will take the case under submission and issue a timely decision.
Thank you.
Thank you. The next case is Harmon versus City of Cincinnati. Good morning. It's Miss Mai, right?
Yes, that's right.
How much time would you like to reserve for?
I would like to reserve 4 minutes. I'm sorry, where will the light display?
Oh, I'm sorry. And I was terrible with that, so
Okay.
thanks for reminding me. It's right there, and when you have a minute left, I'll put the yellow light on.
Okay, thank you.
You said 4 minutes?
4 minutes, please.
Whenever you're ready.
Good morning. May it please the court. My name is Lauren Mai. So the essential question before the court today in this appeal is whether there was a layoff. This court does not have jurisdiction to answer that question. It can only be answered by interpreting the collective bargaining agreement and in the collective bargaining arena.
So you're saying the only way that, the only person that can determine what layoff, whether this is a layoff, is the arbitrator in the grievance?
So I think there are really two ways. There could be an agreement between the city and the appellees, Mr. Herman and Mr. Beasley. So if this was a traditional layoff, if the city had issued a notice of a layoff, if it followed the statutory procedure for a layoff, there would be no dispute. We would recognize this as a layoff. That would obviously result in a finding that a layoff occurred. The other way, though, requires an interpretation of the collective bargaining agreement. That can only be done through a labor arbitration and grievance procedure pursuant to the contract. That's the heart of the issue here, is that the
Didn't the commission already determine it was not a layoff?
that was their decision, which I think is correct, but they also didn't have jurisdiction to make that decision. And I can discuss that more, but that was really made in the...
Well, yeah, why not? Like, why were they not the appropriate body to determine whether this was a layoff?
So pursuant to 4117.10, which is the statute that controls some of the collective bargaining rights in Ohio, I think there are two important provisions that kind of walk you through why the Civil Service Commission does not have jurisdiction. The first provides that an agreement between a public employer and an exclusive representative governs the terms and conditions of employment. Case law throughout the state has found that a layoff and the procedure used in the layoff is a term and condition of employment. So that means the collective bargaining agreement that's in place in this case between Code and the City of Cincinnati controls how a layoff occurs and whether a layoff has occurred. So
But
then,
your
the
position is that it wasn't a layoff, right?
I'm sorry, what's
Your
that?
position is that it was not a layoff.
That's correct.
Okay. So when you go into the CBA, what provision would govern this? Because ultimately, we have to go into the CBA.
Right. So there are a lot of different provisions within the CBA that discuss what is a layoff, again, the proper notice, things of that nature. The only thing that the appellant or the appellees can cite to in this case is their individual right to challenge the procedural aspect of a layoff. It does not give them a substantive right to challenge this overall question of whether there was or was not a layoff. If they had that right,
But doesn't the CBA specifically, pardon me, but
No,
doesn't
go
the CBA specifically provide that if it's an issue that's not within the CBA, then it's not governed by the CBA?
it does, but here the statute controls over any, the CBA has broad language. Here, the collective bargaining rights of a public employee in Ohio are controlled comprehensively by 4117. 4117 indicates that if a term and condition of employment is covered by a layoff, which their contract covers layoffs, then that can be controlled only by interpreting the collective bargaining agreement. That can only happen in the labor arena. It cannot happen before the Civil Service Commission. They don't have the jurisdiction to be able to make that decision.
So let's assume that it's a layoff, and you guys framed it as a layoff. There was no question about that. So they come to Civil Service Commission and say, we're challenging these procedural aspects of the layoff. And you look at their complaint and you say, those aren't procedural, those are substantive. So at that point, who decides whether they're procedural or substantive? The Civil Service Commission or some other entity?
So I think at that point, it would be the Civil Service Commission there has to be a determination that there is a layoff. If the Civil Service Commission decides that they need to answer the question of whether there was or was not a layoff, again.
No, there's no dispute. There's
okay.
no dispute that there's a layoff.
I'm sorry, could you repeat your question?
Yeah, so there's no dispute there's a layoff. You all call it a layoff. That's what it is framed as. So they, relying on that provision of the CBA, come to Civil Service Commission and say, they're not applying the appropriate procedures for a layoff.
Right.
And you look at that complaint and you say, that's not procedural. They're really challenging the substance. So you then say to the commission, this is a substantive challenge, it's not a procedural. Like, doesn't the commission then have to decide that?
So I really don't foresee that situation occurring because when
I know, but it's occurring, all right? You got to assume it's occurring. So my question is, who decides?
So I think in that circumstance, if it is truly related to a process question, then the commission would have the authority to answer that because the CBA does provide for the individual appeal rights related to the process. That there's no dispute about that. But when we talk about process.
Okay, well, so then the CBA says you can appeal the process on layoff to the commission. So then, based on that logic, could the commission not determine whether or not there is a layoff, just like they could determine whether or not it is procedural versus substantive?
I think it is nuanced, but I believe that there is a distinction here, because when we're talking about process, we're talking about, did you have more seniority than another person? Did the city provide the proper notice? Things of that nature. So in regards to the question about, I just have a hard time foreseeing a situation where that would actually occur, where there would be this substantive question underneath, because the process is so distinct from a question of whether or not there was or was not a layoff.
So your basic argument is that the commission did not have jurisdiction to pronounce that this was not a layoff, right?
Right.
That they couldn't do that.
It's the basic argument is that the appellees, Mr. Harmon and Mr. Beasley, went to the wrong forum. They cannot individually litigate this question. And the reason for that is because the city is going to be faced with inconsistent decisions. There is an active labor arbitration that's been filed with the exact same issues filed on behalf of Mr. Harmon and Mr. Beasley.
Is
by
that in the
labor union.
record?
It is.
Where would that be in the record?
I'm sorry, which part?
The labor arbitration, the grievance.
It was cited in the underlying briefs and it was attached to the motions.
Okay, so the grievance that you're saying is duplicative of what they're arguing
Yes.
is attached to.
It was filed with, I believe it would, I can get you the exact citation, I don't have it
No,
before.
that's okay.
But it was attached to the briefing in the
Okay.
trial court. So there's a copy of the grievance that was filed by the labor union as well as the individual appeals that were filed by Mr. Harmon and Mr. Beasley. And if you look at those, the language is a little bit different, but the actual issues in both of them are the same. They're citing seniority rights, they're saying that the, contractual provisions regarding the order of layoffs was not followed, things
The
like that.
seniority rights, that's all the process piece.
Right, but
So
that-
you're saying they have to go through this grievance process to determine whether it was a layoff, and then they could raise individual process issues in front of the commission?
Yes, so really part of their problem is that not only did they raise the issue in the wrong place, they raised it at the wrong time. So the reason that the Civil Service Commission lacks jurisdiction is because there's been no determination that this is a layoff. If there was, again, if the city conceded this was a layoff, or if there was a determination from a labor arbitration that this was a layoff, then Mr. Harmon and Beasley can proceed to the Civil Service Commission.
So I want to push you
Sure.
on the predicate that the arbitrator has to decide whether there was a layoff or not. Like, where is that in the CBA?
So it's not in the CBA, it comes from 4117.10. What that says is that a term and condition of employment is governed by a collective bargaining agreement. A term and condition of employment has been interpreted by courts throughout the state as to cover layoffs and layoff procedures. If you look through the CBA, you're not going to see a definition of a layoff. That's not included in there, and there are lots of things in collective.
Here's where I'm struggling with what you're arguing. Your position is that it's not a layoff. The CBA is silent into this not a layoff situation, and yet you're saying that the CBA governs it and that the arbitration process was mandated, specifically in determining that it was what you would hope not a layoff. So I'm having a hard time how the CBA governs on something that it's silent on.
Well, it's not silent on it.
On your position. Now,
Sure.
the other position is that it is a layoff. Okay, well, that's a different matter.
So, and maybe I can clarify this. The CBA does reference the terms and conditions of employment. And again, that's part of this entire scheme of collective bargaining in Ohio, is that is a terms and conditions of employment is a term of art. It's a mandatory subject of bargaining. It must be covered by the CBA. Layoffs are a term and condition of employment. So if you connect those dots together, it must be covered by the CBA, and it has to be addressed by interpreting the CBA. So those are the steps.
But
that
I
you
think getting
follow.
back to Judge Zayas's question, if you guys make something up, this TEL or whatever, that is different than layoffs, I mean, how do we know that the CBA governs that?
So the CBA, if Mr. Harmon and Mr. Beasley's argument is predicated on the fact that TEL or TEL as we refer to it, is a layoff. So that's the claim that they are bringing for the Civil Service Commission. So to interpret that, to see if they were right, that's why we have to go back to the CBA. It's not whether TEL is covered in the CBA or not. It's because all of their claims are predicated on a finding that there was a layoff, and that's what connects us back to the collective bargaining agreement. The other issue I would like to address is the fact that Mr. Harmon and
If I could,
Oh, sure.
the CBA in section 5.1 specifically says, for any and all terms and conditions of employment not specified in this agreement, no employee in the bargaining unit waives any individual right under the city charter, city code, city rule or regulation, or state and federal statute, constitutional principle, or common law. So it seems to say there that if it's a TEL, that it's not governed by the CBA. Do you read that differently?
I do read that differently
Okay.
because I believe that that's referring to individual rights such as, the anti-discrimination statutes and things like of that nature, these individual carve-outs. Mr. Harmon and Mr.
But
Beasley,
it's saying any and all terms and conditions of employment. So your argument is predicated on terms and conditions of employment, and you're saying that the CBA governs terms and conditions of employment. Here it specifically says that if a term and condition of employment is not specified in the CBA is not going to govern it.
and I think that's where you have to look at this in the picture of the entire collective bargaining scheme that was established by 4117. So that's filling in the blanks here. And so the language of that, I understand, I hear what you're saying as far as that it's saying that if it's not specified, but I think when you interpret terms and conditions of employment generally in the context of 4117 and the case law that interprets that, that directs you back to the collective bargaining agreement because a term and condition of a layoff is a term and condition of employment.
Because here's another section, the CBA section 8.1 talks about if there's any dispute or difference of opinion concerning an issue of matter that's addressed by the city civil commission rules or which could be heard, right?
Right.
So the could be heard goes back to this, whether it's a layoff or not.
And I actually think I think that the language that you cited supports the city's arguments. This 8.1 is the definition of a grievance. Mr. Harmon and Mr. Beasley's labor union has filed a grievance. So their own labor union has taken the position this is not an issue that could be heard by the Civil Service Commission. By filing a grievance, they are saying this is something that must be decided through a labor arbitration.
But
Well, but
that
I'm
case is not before us.
Correct.
But I'm
And
not
so-
sure that's accurate because they could still appeal the procedural aspects of the layoff in front of, if it is a layoff, in front of the commission. So like, there's seeking maybe substantive relief before the arbitrator and procedural relief before the commission. It's not inconsistent, is it?
Well, again, if you're asking the commission to decide the substantive issue of whether a layoff occurred, they cannot bring that question in their briefing. Again, the argument is predicated on the Civil Service Commission. Either one has the ability to make this determination, or two, it's just a foregone conclusion that TEL was a layoff and that there's no dispute over it. So it's the substantive question that they cannot bring in both forums. And I'm sorry, where's my time?
You're actually at the end of your time. I'm not going to
Okay.
count any of the questioning against
Okay.
your rebuttal time, so you'll have 4 minutes.
Thank you.
Morning, Your Honor. May it please the court. My name is Rob Stoker, and it's my pleasure to represent Mr. Harmon and Mr. Beasley. The trial court's findings should be affirmed because it had the proper subject matter jurisdiction to hear the controversy, and it arrived at the correct conclusion. In the essence, this is a procedural due process case brought by individual litigants to exercise rights guaranteed to them by the revised code, the Civil Service Commission rules, and the collective bargaining agreement agreed to by the city. The question, I think, is should Harmon and Beasley have been granted a full appeal before the Civil Service Commission? And the answer to that is yes. The city's argument that the trial court lacks subject matter jurisdiction is flawed for several reasons. First, just because Harmon and Beasley's union have filed a grievance which is ongoing and active is irrelevant. As Judge Zayas pointed out, the union is not a party to the administrative appeal. It's not a part of this case. And Harmon and Beasley individually have absolutely no control over what the union is going to do with the grievance. The union could settle it. The union could win, the union could lose, and Harmon and Beasley have no control over any of that process. What Harmon and Beasley do have is their individual rights carved out of the agreed-to CBA between the city and the union. And that language in 10.1B of the CBA is what brought Harmon and Beasley to the Civil Service Commission.
But if it's language in the CBA that we're worried about, wouldn't that be within the province of the arbitrator to interpret at the end of the day?
I don't believe so, Judge. I think the language in the CBA is the gateway that says Harmon and Beasley can leave the CBA forum and get to the Civil Service Commission. 10.1B is their out. Then they get in front of the Civil Service Commission, and they both file appeals. And before anything substantive happens, or really anything at all happens before the Civil Service Commission, in the record, you see an HR analyst from the city's central HR department saying, TEL is not a layoff. You don't get an appeal under Rule 17. There's a foregone conclusion by someone not empowered to make that conclusion that TEL is not a layoff, therefore they don't get hearings. So I believe Harmon and Beasley properly exit the CBA arena, they get into the Civil Service Commission arena, and then the Civil Service Commission doesn't give them the due process to which they're entitled.
But the city's argument is the Civil Service Commission is, they would decide the procedural issues that you're raising, like seniority and all of that kind of stuff. But the actual idea of is this a layoff has to be determined by the arbitrator first before they can get into the commission.
I don't know if that's true, and under the facts of this case, we can't even get there because the Civil Service Commission never held a full merits hearing on the issue. I think had the Civil Service Commission held a full merits hearing on the issue, issued the subpoenas that Harmon and Beasley asked them to issue, took testimony under oath subject to cross-examination.
But you're saying having a full merits hearing on the issue of whether it was a layoff, right?
I think they could have a full merits hearing with both questions. Is this a layoff, and was the procedural aspect done correctly? And
The city's saying they can't do that. The city's saying first determine in front of the arbitrator if it's a layoff, and then argue your procedural issues in front of the commission. This is my understanding of the argument.
I understand the city's argument that way too, but I think the Civil Service Commission could have the hearing and reach the conclusion they're not the right body to adjudicate whether or not a layoff happened, and then enter and continue a decision on whether the procedural aspects were correct once a labor arbitrator determines the question. But I think all of that got thrown out when Harmon and Beasley were just dismissed from the outset. And I think that's really the procedural problem we need to address, because I think, as was mentioned during questioning of my friend on the other side, if the city just makes up terms of actions that have designated processes of appeal and then denies people the ability to appeal those actions because the terms are made up and not specifically spelled out, I think that's disastrous for due process rights on a whole host of things.
So are you positing that what the commission is supposed to interpret is the meaning of layoff within the confine of Rule 17?
I think it has that ability to do, and it has the ability then also to determine the procedural aspects. What the commission would do within its powers, we don't know because the commission never got to that point. And I think that's really one of the problems here is Harmon and Beasley got stopped short of where they should have been entitled to go. And if we had a full merits hearing and a full record hearing before the commission, and the city disagreed with whatever the commission's findings were, or Harmon and Beasley did, then we could appeal that record. But we never even got to make the record in that case. And that is sorry.
I'm sorry, is it your position that the determination of whether it's a layoff or not can be properly held through the grievance process and alternatively could be properly held by going straight to the commission?
I think that's true, and I think we find support for those sort of issues both within the case law, and we cited it in our brief in this court. Take, for example, an employee who is disciplined, and the labor union says the discipline violates the CBA, and the employee says, I was also disciplined in violation of Title VII because of some of my protected characteristics. Both adjudicative bodies in that case, the labor arbitrator and the presumably federal courts could make determinations on the issue. Similarly, an overtime case. Employee says you didn't apply the overtime provision of the CBA correctly and you violated the Fair Labor Standards Act. Both cases can proceed. So,
But in this case, you have the specter of the arbitrator saying, this is not a layoff. Simultaneously, the commission could say, yeah, it is a layoff, and you violated their procedural rights, and therefore these two city employees get these benefits, or everybody else is denied them because the arbitrator has said there's no layoff. I mean, I think that's the crux of the city's argument in terms of the potential specter of inconsistency.
That's certainly possible. And if that happens, I suppose, we could come back to common pleas court and sort it out, or live with an issue that I guess happens from time to time where other city employees, some choose to fight their discipline through the grievance procedure, others take it directly to the Civil Service Commission. But since we have here these two individual employees exercising their individual rights, I'm not necessarily sure what, and as we argued before, what the union does matters because they're two completely separate entities. I mean, if the union decides to fold tomorrow, then what happens? I don't know, but I think Harmon and Beasley still get to keep going forward. Going back to the second argument why the city is wrong about the trial court needing to be overturned is the question under 2506 is not what the quasi-judicial body actually did, but what it should have done. And in this case, I think we see there should have been a hearing. The July 2, 2022 exchange, which is in the record at the trial court level, really sort of fleshes that out, that there are so many unanswered questions, that there are issues that cannot be determined simply from the filing of the one-page appeal notice that the Harmon and Beasley had to file at the Civil Service Commission. They did submit some briefing to the record, but then at that time their counsel was, now Judge Jenkins, points out that the memo that the city manager circulated about the TEL program talked about financial hardships, and then on July 2nd.
But doesn't that go then to whether it's a layoff? I mean,
Well, it could, but I think it also goes to the fact we need a full hearing to determine that. Because to finish my point, we've got in the written record a city manager memo, and then at that point we've got one of the HR personnel at that hearing saying, well, this was about safety, we wanted to separate people. That perhaps is a good question. The only way we're going to flesh that question out is cross-examination under oath at a full merits hearing. And that's really, I think, again, the problem that I see is these gentlemen were denied their full hearing rights. And there should have been a quasi-judicial.
what would you point to as authority as to support that they were denied their full hearing rights?
Because the subpoenas were sent to the commission and not issued. The Civil Service Commission rules allows for subpoenas to be sent, cross-examination, questioning under oath, presentation of real evidence. You'll see in the record at the trial court level, there were 4 or 5 subpoenas issued, both for documents and testimony, and the commission never issued them. They never went to the people to whom the subpoenas were directed. There was no court reporter. The reason you have a transcript is the meeting was recorded and then transcribed after the fact. There wasn't any live court reporter there. And everybody who spoke was not subject to cross-examination, which really gets to the heart of the evidentiary hearing. Each side.
And I understand where you're coming from, but what would you cite to as authority to say this is why they were entitled to a hearing and not to just an appearance?
2506, the statute, that they should have had a hearing because under Civil Service Rule 17 and 12, which are the layoff provisions, it had every indicia of a layoff. And the only thing that changed was the name. And so they should have had a hearing to determine whether or not this name change was dispositive of the underlying actions, which by all accounts, my position is, were a layoff. They were relieved of work from lack of funds, they went home, they were told when to come back.
And all of that is going to be litigated also in front of this arbitrator in the grievance process.
I think that will be part
So
of the
there's going to
order.
be all of that evidence, cross-examination, everything being done in front of the arbitrator.
Yeah, there's an active and ongoing grievance, and yeah, I believe much of that will come out. One of the things, and it didn't come up in the brief, but it occurred to me afterwards, is many of the witnesses whom Harmon and Beasley wanted to subpoena are no longer city employees. So I think there's perhaps some sort of harm in not getting the hearing done expeditiously and getting their testimony while they were still city employees. So this matter absolutely needs to be remanded back to the Civil Service Commission. There was a due process right violation for the individual employees. The trial court got it correct, and this court should affirm.
And when you say a due process violation, are you talking about statutory or constitutional?
Statutory, that they have this due process right to this hearing to appeal the aspects of their layoff.
Thank you.
Thank you, judges.
Thank you. Ms. Mai, you have 4 minutes for rebuttal.
And I'm going to interrupt you before you
Sure.
start. Apologies.
No problem.
So getting back to my questions to opposing counsel, Rule 17 uses layoff. Why would it not be within the province of the commission to interpret what layoff means under Rule 17, which could be the same or it could be different than what it means under the CBA?
So, again, first of all, I think it might be helpful for you to know, so the Civil Service Commission has jurisdiction to hear these appeals from all city employees who are in the classified service. Code's contract is the only one that has this individual procedural appellate right. So the civil service rules, in my understanding, are written more broadly to address all of city employees in the classified service, whereas the code employees have the specified procedural rights within their contract. That's a bit of a distinction compared to the other bargaining units within the city. But again, I think this all goes back to 4117, and I think it's interesting both in the arguments in the briefing before the court that counsel for Mr. Harmon and Mr. Beasley has really never addressed the issues, the arguments raised by the city in 4117. He stated during the arguments, we'll come back to common pleas court and figure this out if there are inconsistent decisions. Like, how are we supposed to do that? How is the city supposed to interpret an order from a court as well as a binding legal order from an arbitrator that have inconsistent findings? The
Well,
whole
it just sounds like the people included in the grievance process would have one ruling and potentially these appellants would have another.
But practically, I mean, we're talking about bumping, one of their arguments is that they should have been bumped, other people should have been bumped in lieu of them. So we're going to have an individual employee who said that this is not a layoff and that the city followed the procedures properly. Mr. Harmon and Mr. Beasley are going to have an order saying this was a layoff. You didn't follow the proper procedures. You get to bump somebody else who is laid off. I don't see a way practically how the city could square two completely inconsistent decisions if that were to occur.
So let me ask you this. Can the CBA allow for a particular matter to go to the arbitration process or alternatively to go elsewhere, in this case to the commission?
If I'm
In
understanding.
other words, with 4117.10A, and I think it's A that you're referring to, are you saying that that would disallow that?
If there was language that was that specific, kind of at the granular level discussing this, I believe you could contract for that. But that's the whole purpose of these collective bargaining rights, is that you are bargaining collectively, you are forfeiting your individual rights. And unless there is specific language that there was a bargain made, that was the intent of the parties, you cannot read that into the collective bargaining agreement that they have this substantive right to take their individual issues and litigate it on an individual basis before the commission, when everything else about the collective bargaining scheme in the state of Ohio defers it to the labor arbitration process. So
But I
that
think
the
that's the
question,
argument, is that 5.1 and 8, I think it's 8.1, by its language is allowing that opportunity.
again, from the city's perspective and our position is that it does not allow that. Again, it is limited to the procedural rights. The overarching question of whether a layoff did or did not occur cannot be addressed by the Civil Service Commission. And again, that is consistent with the entire purpose of collective bargaining in the state of Ohio, is that you are answering these questions in the whole. You are not facing challenges from individual litigants in a two-pronged attack. And then I know I'm about out of time. I'll just say briefly, Mr. Harmon and Mr. Beasley are not appealing from a quasi-judicial hearing. So they had an appearance before the commission. There was an open question as to whether their appeal was covered by Rule 17, because it goes back to this fundamental question of whether a layoff did or did not occur. So this commission properly scheduled them for an appearance. They made arguments before the commission, and the commission decided, no, you're not covered by Rule 17. So that's why there's a separate reason that the court lacked jurisdiction, is because they were not appealing from a quasi-judicial hearing.
All right, thank you.
Thank you.
Thank you both for your arguments this morning. We will take the case under submission and issue a timely decision. Next case is U.S. Bank versus Ty. And how much time would you like for?
I'd like to reserve 5 minutes of my time for rebuttal.
5 minutes. All right, whenever you're ready.
All right, Your Honors, may it please the court. This is a standard garden variety appeal of a summary judgment in a foreclosure action. We raised 4 separate assignments of error, but for the purposes of today's arguments, I would like to stand on our briefing for the 2nd, 3rd, and 4th assignments of error. And I'd like to focus the discussion today on our first assignment of error, the hearsay question. Unless the panel has any questions for me on those other assignments of error, I'm going to focus my arguments today on that first assignment of error.
And I do have questions on the second assignment of error, but I want you to go ahead with your argument on the first, and
I'll address them as they come up.
Yeah,
Thank you.
exactly.
Okay, so having said that, in my view, the primary issue here is that the court granted summary judgment over our objections to 2 specific pieces of evidence, a notice of acceleration and a loan payment history, or a loan servicing notes that were offered into evidence through the affidavit of the employee of the current loan servicer, but they were created by the prior servicer of the loan. And the affidavit from the current servicer doesn't address any of the core issues of 8036.
So wait, you're arguing that the notice of acceleration and the payment history records were hearsay?
I am. I'm arguing that they were hearsay and that they should not have been admitted.
All right, so let's take that first to determine if they're hearsay, because I thought I saw some case law that said the notice of acceleration is not typically considered hearsay.
Exactly, Your Honor. I wanted to address that issue. First of all, our opinion is that case law is incorrect. And I think even the appellee concedes that, because in their brief, they noted that the notice of acceleration was offered as proof of their prima facie foreclosure case. One of the elements of foreclosure is that the plaintiff has to prove that they've complied with all conditions preceding to foreclosure. And in this particular mortgage, that involves the proper sending of a notice of acceleration in 2 prongs. Number 1, that it was actually sent, and number 2, that it contains specific language.
So that it was sent, for that purpose, it's not hearsay.
Well, and that's, and quite frankly, Your Honor, I'm just going to take my lumps in this answer. I don't understand the argument that if one of the elements of a foreclosure action is proof that a notice of acceleration was sent, the argument that we submitted it as proof that it was sent, and that's not to establish the truth of the matter asserted. I think that if that is a prima facie element of their case, if they're saying that that's why it's being admitted, that is to establish the truth of that specific matter, and it's absolutely subject to a hearsay analysis.
But was there an affidavit that said, here's the notice and we sent it?
Well, that's the problem, is the affidavit is incredibly vague. The affidavit, first of all, says that if we have any records from a prior servicer, and they don't identify the prior servicer, then we have a process in place to incorporate those records into our own so that they become our own business records. And that's what the affidavit said. If we look at
But are
8036...
you're not suggesting that any time someone acquires a prior company, that those records of the prior company could never be admitted into evidence through the business records if the new company says, hey, here's our process, and checks all the boxes under the business records rule, even though they didn't create those records, they just acquired them from the prior company?
That's absolutely right, Your Honor. We don't want to say that there are no circumstances where third-party records would be admissible. However, we would like this court to just apply its own analysis from the Gill case, which we cited in our brief, and from a case after Gill. In Z, which we cited on page 18 of our brief. The Gill case, I think, is really instructive here because the appellee cites that case for the proposition that third-party records can be admissible under certain circumstances. And our argument is that the devil's in the details because the factual distinctions between Gill and this case are very, very dramatic. First of all, Gill was a case that was the result of a trial. And there was a trial witness who was subject to cross-examination, and she testified that she was an attorney and she was an employee of the entity that created the record. And she testified to the fact that those records were normally created by that business, that they were created at or near the time of occurrence, all of the elements of 8036. Going back to
But
this...
the company in this case went out of business, right?
Not at all, Your Honor. NationStar is still one of the largest loan servicers in existence.
I guess I'm misunderstanding. Okay, so they would have been able to get somebody from there to testify?
Certainly.
Okay.
Yeah, they simply transferred servicing immediately prior to the filing of the case.
But what about a situation where a company goes out of business and there is nobody to testify? Or are they just out of luck?
Well, I think that is problematic. I mean, again, this court's own opinion from In Re Z, talks about a situation where the witness lays a predicate foundation for his own company's business records, but doesn't lay any foundation for any adopted records. And this court talks about how you refuse to assume away the foundational requirements. And I submit to you that that is exactly what happened here, is that the trial court simply accepted an affidavit that doesn't even mention the name of the entity that created the business record, is utterly silent on whether that entity normally creates those records or when it was created. It simply said, hey, we may have gotten something from someone, and if so, we've incorporated it into our own records. If the appellee's argument is that case law says that third-party records can sometimes be admissible, our argument, and I think this case, is all about where is that bar set? Maybe the bar doesn't necessarily need to be as high as it was in Gill. Maybe that was a case where they cleared the bar with space to spare. But certainly the bar should be higher than an affidavit that doesn't even mention the company that created the record or any of the circumstances, any of the foundational requirements of 8036. None of them were even mentioned in the affidavit. They focused only on the line from Felty and the line from other cases throughout Ohio that has said we look at whether there is an indicia of trustworthiness, and they completely ignored the holding that that only applies after the requirements of 8036 have been otherwise met. Those requirements simply weren't met here.
So are you saying that there should never be an adoptive business record rule?
Not at all.
Okay,
I mean,
so
again, Your Honor,
when is it appropriate then?
I think it's inappropriate when you have an affidavit that doesn't specifically address any of the foundational elements of 8036. If the affiant can't even testify to the name, or first of all, if the affiant can't even testify definitively as to whether or not they are relying on third-party records, because again, this affidavit only says that if we are relying on them, this is our process.
Oh, it doesn't say that our process is we take the records from the other company and we rely on them and incorporate them into our records?
No, it does say that, but it
Okay,
says.
that's not a good enough?
Well, it says if we are relying upon third-party records, then we do everything that you just said. But it doesn't say that in this particular case, this is a third-party record. It doesn't even, it just simply says that if it is, this is what we
So
do.
if it were more definitive, if the affidavit said, we got these third-party records, we relied on them in this particular case, then that's fine for adoptive business.
In my view, yes, that
Okay.
gets us closer to clearing that bar.
It's just the way this affidavit is phrased under this particular case that you're having an issue with.
But were the records, and forgive me, I don't have the affidavit in front of me, were they attached to the affidavit?
They were attached to the affidavit, but again, that becomes the nature of hearsay. This is a document that was produced by a third party that's being offered into evidence by the
Well,
affiant.
but if they're saying, if we're relying on documents, here's the procedure we're following, they've got these documents that they're relying on because they filed them with the affidavit, like, where are they missing the bar here?
I would submit that they need to be more specific. We are relying upon records that we received from a third party. This is the process that we use to verify that those records are accurate. This is the process that we used to verify that those records were regularly created by the entity that created them, by a person with knowledge at or near the time of the event. Again, all of the foundational elements of 8036. What the appellee is proposing here is an adoptive business records rule that subsumes the business records rule itself. Under their proposition of law, it is easier to admit documents into evidence that were received from a third party than it would be for them to admit their own records into evidence. Our argument is simply that it has to be a higher bar than that. Maybe it doesn't need to be as high as Gill, where they had an employee of the company that made the record testify as a trial witness. But certainly it has to be better than an incredibly vague affidavit with no specifics whatsoever. In my view, if it were up to me, I would argue that this is a question of fact that's not appropriate for summary judgment and would require a trial. But that's my opinion.
You are at 11 minutes unless the panel has more
So I have
questions.
one quick question. Objections were filed, right?
Yes, Your Honor.
Did the trial court rule on the objections?
They did, but the ruling, overruling our objections and granting summary judgment was incredibly vague. That goes to one of our other assignments of error. Unfortunately, we were in the position when we drafted our brief that the final judgment was so vague, we weren't really certain what issues we lost on. And I essentially had to rehash all of our oppositions to summary judgment and all of our objections to the
It's the
magistrate's
same entry that
decision.
was attached to the brief, is the one you're referring to, right?
I'm sorry, Your Honor?
It's the same entry
Yes, Your
of the
Honor.
trial court that was attached to the brief, that's what you're referring to?
Yes, Your Honor.
Because in this entry, I don't see I don't see that it overruled, I don't see like any pronouncement with regard to objections.
Your Honor, I apologize. I may be mistaken in my recollection. I don't know the answer to that question. I would have to go back and look at the docket. There may be two separate entries, one overruling the objections and the second granting judgment.
Okay, because my other question, which is related, which goes to finality, in the entry that's attached to the brief, I don't see things like the amount of the judgment, the priority. So my question is there an actual judgment here?
Is this a final appeal order?
Is this a final appeal order? That's
Your Honor,
correct.
neither party raised that in their brief.
But if we don't have jurisdiction, we don't have jurisdiction. Finality goes to our jurisdiction.
Certainly. Well, if the court finds that this is not a final appealable order, then I guess we go back to that under the trial court and they clean up their order and we come back and do it all over again.
So it goes back, I don't know if there's another, but, you know,
I-
at least what's attached here, I don't see priority, I don't see amount, and I don't see a pronouncement on the objections.
Yet frankly, Your Honor, none of us addressed that issue. So, yeah, if this court finds that it's not a final appealable order, all we can do is go back down and ask the trial court to clean up their order.
Thank you.
Thank you.
You went a little over. I'm not going to count all that against you, so you'll still have 4 minutes for rebuttal.
Thank you, Your Honor.
If you know the answer, is there another entry besides the one that's attached?
Your Honor, I was just checking that, and I discovered that the amount due and owing, interest rate, the applicable due date, priority, that was addressed in the magistrate's decision.
That's
And then the
correct.
trial court adopted the magistrate's decision in a final judgment.
But did the trial court specifically address the objections to the magistrate's decision?
It did not, Your Honor.
Okay.
But it's not required to, is my argument.
So there is no separate entry besides the one that was attached to the appellant's brief overruling objections?
Correct.
They weren't mentioned at all?
Correct. What specifically the trial court addressed was, I can tell you, it expressly stated that the trial court had reviewed the foreclosure complaint, the summary judgment motion, and the evidence supporting the motion. And the order expressly adopted the magistrate's decision. My analysis indicates that that is sufficient under Ohio law. It's an abuse of discretion standard of review that applies here.
But we have cases out of our court, like the Chan versus, Tazar case, that says where the record does not affirmatively reflect that the trial court considered and ruled on the objections to the magistrate's decision, the court should reverse the judgment of the trial court and remand for an appropriate review of the objections. So how in this case can we say that the court actually ruled on the objections when there's no mention of them?
Right. Well, the fact is that the case had been thoroughly litigated through 2 summary judgment motions. Objections have been filed to both both magistrates' decisions. And in the first case, it was by both parties. Before that magistrate's decision, basically, it did not get addressed by the trial court. And then the subsequent summary judgment motion was ruled on by the magistrate. The borrower objected, and the trial court reviewed and adopted that magistrate's decision. And what the court's entitled to do is to take into account the entire history of the litigation, and it's not required to set forth specific reasons supporting its rulings on the objections to the magistrate's decision. I'm referring specifically to the Fafel case from this.
I agree with you on that. I don't think the court has to say
Yeah.
specific rulings, but doesn't the court at a minimum have to say objections were filed and I've considered and reviewed the objections and I overruled them?
I don't think so, Your Honor. I mean, I think that under the circumstances of this case, I think the trial court, complied with the broad outlines of what it's required to do under Rule 53. And I think that the trial court did not engage in any arbitrary, unconscionable, or unreasonable decision-making in not addressing the magistrate, or the objections to the magistrate's decisions specifically.
Can I steer you back to the affidavit?
Sure.
Which I'm looking at right now. I guess I have a concern in paragraph 3 that this gets to the point that opposing counsel is raising, is that how generic it is, where it says the business records of Rushmore Loan Management Services LLC, and then it ticks through the various requirements of the business records rule. And then if it was serviced by someone else, we've got these processes in place. I guess my concern is none of this is tailored to the actual documents. Like, you could stick this affidavit on any document anywhere in the company and it seems applicable to it. I mean, my understanding of the business records rule is you need to say that this document here satisfies the requirements of 8036. So how do you respond to that?
Well, the other side of that, Your Honor, is that these are mortgage servicers. And mortgage servicers transfer servicing rights to loans
Oh, I
to
know.
and forth all the time.
I understand that.
And the affidavit is specific about the types of records that go back and forth. Pay histories and notices of acceleration are among them. And I think that because, the specific types of documents objected to here really relate to the heart of mortgage servicing, there should be kind of a presumption of reliability here. And, it's not as though it's records of, office supply orders or something like that. I mean, this is what mortgage servicers do. I mean, they apply payments to loans, and they send out notices. And also, too, it's worth considering the standard of review. The standard of review for admitting evidence is an abuse of discretion standard of review. And what I heard, what I read in the borrower's brief was that they were arguing that there was a de novo problem with the business records exception to the hearsay rule as applied by the trial court, and that they wanted a different rule applied. But when we get to the issue of reliability, that's definitely within the scope of the discretion of the trial court. So the question then becomes, is it arbitrary, unreasonable, or unconscionable decision-making to admit that evidence?
But I think it's also, if you look at the Johnson versus Abdullah case the Supreme Court recently handed down, it's also like, did the court make an error of law?
Yes.
And if the court did not apply 8036 in a proper manner, that looks like an error of law.
Well, I mean, it has to do with reliability, I think. And the issue here is, the records are reliable because these are ordinary and customary procedures that the servicer, in this case, applies with respect to the servicing rights to other loans that are transferred to it and the records that come along with it. It's a general policy, to be sure, but it's also a policy that is at the heart of what mortgage servicers do. And I would suggest that when it comes to issues of reliability, that it's not a legal question, really. It's more of a question of discretion for the trial court. It's a legal question if the elements of 8036, I think.
But that goes to
specific
the
elements.
argument that it should have gone to the trier of fact, that the reliability should have gone to.
I don't believe that it's a tribal issue of fact, though. That's not the issue. I mean, the issue is whether it's admissible, I think, in the first instance. If the trial court decides that it's admissible, then, it's free to, decide whether, the initial burden of the plaintiff is satisfied. And if it is admissible, that initial burden is satisfied. Then the burden is on the other side to produce a tribal issue of fact. So there's really no tribal issue of fact here if the plaintiff has discharged its initial burden, and it has discharged its initial burden if the evidence is admissible.
Was there a motion by the plaintiff to exclude this evidence below? I mean, procedurally, or were they just opposing summary judgment?
They're opposing summary judgment, Your Honor. Yeah.
Can you address whether you believe that a notice of acceleration is hearsay?
Sure, absolutely. It's not hearsay because the content of the notice is not offered for the truth of the matter asserted. The content of the notice involves, you're this many payments behind, this is how much you owe, this is how much it's going to take to bring a loan current, and it contains other language compliant with paragraph 22 of the mortgage. The purpose of that letter is to show satisfaction of conditions precedent, not that the borrower is in default, not how much the borrower owes.
That it was sent?
Yes, exactly.
But you do agree that the other records were hearsay?
They did fit the definition under 801C, yes,
Right,
the
okay.
payment history records,
Payment
because
history.
those records are offered to show, here's how much is due and owing on the loan, this is the date it's due for, this was the last payment, this is the balance, this is the interest rate, that sort of thing.
Okay.
Yeah. And I think the servicer pay histories, I mean, a couple of things that my friend addressed, I wanted to get into. And one of the things that's important to realize here is that the borrowers objected only to the prior servicer's payment histories. That is before 2016, Saxon and NationStar. The borrower did not object to the payment history submitted into evidence by the current servicer. So then the question becomes, if they didn't object to that, then it comes into evidence. And if it comes into evidence, does it discharge, does it satisfy the prima facie elements of foreclosure by the plaintiff? And it does. It covers all the bases. It sets forth the amount due and owing, the interest rate, the due date. So this whole question about the prior servicers really is secondary to the question of whether the current servicer's payment history is sufficient to discharge the plaintiff's initial burden.
So you think even if those records were excluded as hearsay, you had enough with the current
Exactly.
servicer records?
Exactly, Your Honor. And I think for that reason, this court need not risk making new law, so to speak, regarding the business records exception to the hearsay rule, because that issue isn't even live if the court concludes that the trial court was correct in concluding that the records from the current servicer, which were admissible, were sufficient to discharge the plaintiff's initial burden under Drescher. And I think that I also want to address something my friend mentioned about the kind of standards that a witness must satisfy in order to seek the admission of another business's business records. I think it's quite the opposite. It's not the case that my client is arguing for a more simplistic rule. It's arguing for the rule under Ohio law, which is more complex and detailed and contains more standards than the rule of just simply admitting business records from the witness's own business. So the witnesses, let's take them sequentially. When a witness is seeking to admit business records under 8036, that witness must testify as to the three elements. The documents were made at or near the time of the event they described. They were made by a person with knowledge or transmitted from a person with knowledge. And it's the regular practice to keep and maintain those records. Those must be satisfied, as well as other indicia of reliability. But when it comes to the adoptive business records rule, the witness must testify as to those elements as to its own business and testify that the records from the transferring business were incorporated into the transferee business and relied upon in the ordinary course. So that's a much more stringent standard than simply 8036, and it's certainly much more stringent than I think my friend was suggesting.
Well, but I guess again, I'm looking at paragraph 3 of the affidavit, and it says, if the mortgage loan was serviced by another entity, then we would have done X, Y, and Z. Mm-hmm. But it doesn't say, these documents here were serviced by this entity, and here's the process we followed when we acquired the loans from that entity.
Mm-hmm. Right.
I mean, it's really vague.
It's vague, but I think it's enough to satisfy the Ohio law. And, and of course, the other side had the opportunity to produce a tribal issue fact on that. They could have come forward and said, well, we, took the deposition of this person and we looked into it, and they actually don't have very good procedures for incorporating records. Instead, that didn't happen. It's still an adversarial process, I think. So there's two other remaining assignments of error that weren't addressed, and I think one of them gets to your question, Judge Krause, about the party who went out of business. Mm-hmm. So that was Taylor, Bean, and Whitaker. That was the originator of the loan, and Taylor Bean was in title to the note and mortgage. There was an errant assignment, mortgage assignment, that was had been filed and recorded before the one to U.S. Bank that required actually there was a 2016 foreclosure that had to be dismissed on that ground, and then the 2018 foreclosure, which is this action, that issue came up again, and that was the reason that the first summary judgment motion was denied, was because the court, the magistrate believed that there was a tribal issue of fact as to who the current holder was. And then what happened, and then in lieu of arguing that further, the plaintiff sought leave to file an amended complaint to add Taylor Bean as a party and then serve them, and they did not respond. So the idea was to exhaust the possibilities for anyone who could be in a current holder of the note and mortgage. And Taylor Bean had been out of business for a long time, as the borrower had acknowledged. And I think what they've also argued is that the servicers could be holders, but the servicers were never, entitled to the note and mortgage. So there's really no question that, that U.S. Bank is the current holder.
And you are at your time, so.
Thank you, Your Honor.
Thank
And I
you.
ask the court that the court affirm the trial court in every respect.
Thank you so much. You have 4 minutes.
I may not even take that much time unless the panel has
Well,
questions.
yeah, let me ask you.
You're going to take that much time.
To the question I asked opposing counsel, like, did you all seek to exclude or strike this affidavit in the records, or did you just oppose the summary judgment motion and say,
I concede that we did not file a motion to strike the affidavit.
Right.
Our problem is, again, if the affidavit doesn't even affirmatively state that they are relying upon records of a third party. It only says that if they have those records.
right, but then that, to me, suggests, like, you're talking about a tribal issue of fact. Like, I have trouble seeing a tribal issue of fact. I do see where there could have been a path to say, like, strike that affidavit. Like, it violates 803.6, and the court shouldn't consider it.
Well, I guess our concern is from a practical standpoint, to incur the expense of trying to depose that affiant or filing a motion to strike if they've never even met their initial burden by filing an affidavit that is so vague that it doesn't even affirmatively state that they're relying upon third-party records. Why should we have the burden to rebut that? If they never, this is Civil Rule 56, they never met their initial burden. My colleague noted that this court doesn't need to make new law in regards to 803.6 and the Adoptive Business Records Rule. I want to be very clear that we're not asking this court to make any new law. I have the very fortunate position here to be able to argue and cite to cases that not only are cases out of this court, but they are cases that were drafted by members of this panel and were joined by either one other member of the panel or the entire panel. All we're asking this court to do is apply the analysis and the reasoning from the Gill case and from In Re Z, which we cited on page 18 of our brief, and In Re AK, which we cited on page 9 of our brief, for the analysis of what testimony is required to lay the foundational elements of an 803.6 argument, and whether that bar was cleared.
Right, you're not asking for us to reject the adopted business record rule. You're saying that this affidavit didn't cut it.
Exactly.
Right.
And if the panel has no other questions for me, I have nothing else to add.
Yes. All right, thank you.
Thank you.
Thank you both for your arguments this morning. We will take the case under submission and issue a timely decision. The last case we have is State of Ohio versus Prather. Good morning, Mr. Hoffman. How much time would you like to reserve for rebuttal?
I'd like to reserve 5 minutes for rebuttal, please.
Whenever you're ready.
Thank you. And please, the court, Mr. Donovan. I would just like to discuss this morning the second assignment of error, and that is the court's order excluding the testimony of Rondez Collins as a witness. And I wanted to start by noting that there was no proffer in this case of what the expected testimony would be.
Yeah, and I mean, I think that's really problematic from our ability to analyze this assignment of error, because we don't know what this guy was going to say, and then to evaluate how that might have prejudiced your client, I don't know how to do that.
Well, it was a mistake, but I think the background would allow the court to make an inference of what effect his testimony would have had on the case, and that is because it's clear from the testimony that he was a snitch. He directly implicated Mr. Prather. He had 120 pages of a statement, and the police very often use snitches to investigate cases, and this case was no exception.
Now, this case involved a string of aggravated robberies, right?
Correct.
So to which one, or multiple, but his testimony, Collins' testimony would have gone to which one of those?
Well, I believe it would have
incidences?
gone to all of them. I believe that Smith was, I believe he was unable to make an identification. I know he made an in-court identification, but, I mean, realistically, the robber there, they had a ski mask that exposed only his eyes. In the video from the bus, I mean, he didn't pay any attention to that person at all on the bus. He couldn't have identified. The police could not have been led to Mr. Prather through Mr. Smith. And the same with Mr. Meadows. The only way they probably could have been led to, I mean, it's a fair bet that it was through Collins' testimony that that Mr. Prather became a suspect. I mean, he left his phone in the car, Coulter's car, but I think it was early on. They interviewed Collins, got his statement. Mr. Prather was implicated fully, and now, after his prison sentence is fulfilled, he indicated he wanted to testify on behalf of Mr. Prather, which I think a fair assumption is he wants to recant some or all of his statement.
But I think that last phrase, some or all, like, we don't know whether it was some, whether it was all, and whether the some would have been ultimately enough to be meaningful exculpatory evidence.
I understand that, but as far as Mr. Smith's, the aggravated robbery of Jason Smith, I think that with the admission in the record, Mr. Prather's admission during his March 30, 2018 statement to Detective Coombs, it would be unlikely that the result of the trial would change. But I think when it comes to Meadows, I think that during that Mr. Prather's earlier statement and in his testimony in court, he never wavered as not having been the gunman in that case, as being in the back seat, so to speak. And I think that and another thing is that the Papadakis case indicates that this court is supposed to make an inference as to the effect of the testimony. You're supposed to assume that the jury would believe whatever it is that the proffer would be in determining that second element of the effect on the case. And so I think that that there is some traction here with regard to the Meadows counts. And I don't think you have to have a change in the whole trial. I think just one count could be changed, and I think that would meet the Papadakis test. I believe that it's a fair bet that he wanted to recant, and I think that could be inferred from the record. I couldn't find a case where a proffer had to be explicit, where an inference couldn't take the place of a proffer if enough evidence was in the record to allow a trial court to engage in that second test and come out in favor of the defense. And so I think this case meets that test, and I think this court is not stopped by the case law from finding that this testimony of Collins could have had an impact with regard to the counts regarding Meadows.
Was it indicated in the record that defense counsel had actually spoken to Collins, or was this just Collins had reached out to Prather?
She said she had contacted Collins.
So
That's
she,
best
on the
said.
record, counsel explained to the judge that she had actually spoken to Collins.
No, she didn't say that.
Oh.
She said, I have contacted him. I was able to contact him. Those were his words.
That was it.
And he said he's willing to come and testify on Mr. Prather's behalf. That's a quote from the transcript.
So that's all we have. Obviously, she didn't say what he said he would say. Just
Right.
that he's willing to come in.
But you do have a snitch in that you do, and he did say he was willing to testify on Mr. Prather's behalf. And so you have a very detailed statement implicating Mr. Prather, and if he's going to testify on Mr. Prather's behalf, I think you have to assume he's going to depart from that statement at some point.
Right, and he, apparently the statement that he gave to the police concerned counts 1 and 2, is my understanding, or am I not understanding?
Well, I only found a discussion of his, I did find evidence in the record relating to those counts, where he's mentioned with regard to those counts.
Okay, and then Prather was acquitted of those counts.
Right.
Okay.
But I didn't mean to indicate that his statement implicating Prather was limited to those counts. I mean, that's where I could find in the record his being mentioned.
Okay.
But
So the other counts
I should have
that he was
distinguished.
found guilty on, Collins had given, you're saying Collins had given some statements to the police regarding other counts?
I believe every count.
Every count,
I
okay.
believe every count. I think it's very safe to assume that he turned state's evidence on all this.
Okay.
But I should have distinguished in my brief that I was limiting that discussion to what was found in the record with regard to references to Collins in the prosecution. But when counsel said that she had contacted him and he was willing to testify on Prather's behalf, I think that's enough to allow an inference that he was going to depart from his statements, and that testimony, if believed by the jury, would be enough to
That it would be something positive for your client. We
that
can
it would
infer
be,
that.
at least with regard to the counts for
exculpatory.
Meadows, it would change the result. Now, I only wanted to discuss that count, but if the court has any questions with regard to the other counts, I'll be happy to entertain them at this time. But other than that, I'd ask that the court would reverse with regard to that decision, that it was an abuse of discretion on the part of the trial court to disallow that witness from testifying. Thank you.
Thank you. We'll keep your rebuttal time.
Good morning, Your Honors. And Ms. Steer had written the briefing on this, and I don't want to step on her fine work, so I'm really just going to respond to some of the statements that Mr. Hoffman had just made in regards to the second assignment, unless the court has additional questions. In terms of the statements that Mr. Collins did, the statement that he did give, we don't know what that is, other than counsel said that he implicated the defendant. I would take exception with the use of the term snitch. I don't believe that there's anywhere in the record that indicates that he wasn't a co-defendant or a co-participant in this. I'm restricted by the same record as counsel. There's nothing to indicate that he was a jailhouse snitch. I'm walking a line. I don't want to go beyond what I know from the file and what's included in the record. But I don't believe
I don't think
that-
he called him a jailhouse snitch.
But calling
Just
him
called him
a snitch in
snitch.
general, indeed, not just, the negative connotations involved in that, I don't believe are appropriate for here. Additionally, the comments that we don't know which of the counts he implicated. I believe that it would be in terms of an assumption that is made that there were two of the events that involved multiple people. Those were the robbery of Ms. Coulter, who was, her car was taken, and ultimately Mr. Prather's phone was found in that vehicle, I believe. And then the robbery of the bootleg cab driven by Mr. Meadows, those were the two where there were multiple individuals. So I think it's safe to assume that his testimony implicated him in those two and not in Mr. Smith, where it was a lone person, and not Mr. Hurley, in which, while there were other people, even if it did implicate that, he was acquitted of the aggravated robbery.
And in the Coulter count or counts, he was actually acquitted, right?
Yes, ma'am.
Yeah.
Yes, ma'am.
And in the Meadows count or counts, Meadows was able to identify.
Yes, ma'am. That is correct. In terms of
And let me ask you this. I mean, I do have some concern with how the trial court handled this. I realize it was a late disclosure by the defense, but it was someone who was on the state's radar. In fact, you guys, put forward his statement. So obviously we have the proffer issue, but can you speak to the propriety of excluding this witness wholesale in the manner the trial court did?
Yes, Your Honor. I believe that the indication is that, defense counsel's statement about contact with Mr. Collins is apparently Mr. Collins, apparently reached out to my client and indicated that he's willing to come and testify on his behalf. I don't believe that there's anything in the record to indicate that counsel was aware of this prior to this. The court, in making its decision, I believe, was driven by the dilatory actions of Mr. Prather himself. The indication is that this was learned over the weekend. The jury was selected, I believe, on a Monday. Then there was a continuance the next day due to the clothing. The next day was unavailability of the court and of, I believe, one or two of the jurors on that next day that it was continued. So it was the third day, 3 days after the jury had already been impaneled. Now, ostensibly, while I concede that opening argument had not, or opening statements had not been made, we're in the third day after the jury has been selected. Now, and only now, do we have a statement that this person now wants to testify.
But was that, the defense counsel asked for a continuance, or she just was asking that he be allowed to testify?
She then said, I believe she did say that the appropriate remedy would be a continuance, and that's what they were asking for.
That is instead of excluding him, right?
Yes, ma'am.
Because didn't the state claim surprise or something?
We did in that, that is correct, yes. The state said.
Well, how long was your presentation, the state's presentation of the evidence?
The presentation of the evidence, I believe, was 2 days, if I.
So, but this would have been a defense witness, so, they wouldn't have been called until after the state rested. So, I mean, there would have been some time in there to mitigate any prejudicial impact to the state.
In terms of that, then, Your Honor, then we're saying that the appropriate remedy of the court would have been to have no sanction at all, and that then the time additionally beyond the time in the courtroom then is, I believe 2 of those days are the weekend. So I believe that it was Thursday and Friday evidence was taken by, and I could have this wrong.
Right. Right.
If I'm wrong, I apologize to the court. I believe it was Thursday and Friday. The state put on witnesses and possibly the beginning of Monday, but it was on Monday that then defense put on its case. Additionally, absent knowing anything about this statement that he's recanting, not having an opportunity to evaluate in a vacuum, we have no idea. I mean, based on the record before this court, and this goes back to your original concern, sir, about the lack of the proffer. What we have at the moment is that this individual was going to come in, and the only proffer we have about what the evidence is going to be that he was going to testify to is that it implicates Mr. Prather in these cases, that it would be inculpatory, not exculpatory. And anything beyond that is pure speculation. And I disagree that Papadakis says that you can speculate as to this. In Papadakis, the proffer was explicit as to what, I believe it was 2 witnesses in that case, and what they were going to testify to, and that was all presented to the trial court. Absent the proffer in terms of the 4 Papadakis criteria, at the very least 2 of them cannot be properly evaluated. The impact on the trial and whether or not a less severe sanction would have been effective. Absent knowing what the evidence was going to be, it is impossible to evaluate that. So we would say that, one, we think the record does support the trial court's finding as to, well, the court didn't truly make a finding as to willfulness. However,
Well, I think that's part of the problem, is trial court didn't actually make the findings under the appropriate standard.
it did not specifically state them, no, but I'm not aware of any case that says that in making a ruling on this, you need to definitively evaluate the criteria and say, I'm making a finding as to this, I'm making a finding as to that. The trial court does, from the context of it, we can determine that the court felt that the state had been surprised, and the state claimed surprise on that, and it happening that there was, the fact that the witness, the existence of the witness predated by 3.5 years, a dramatic change in testimony, if that is in fact what was going to happen, and in order for it to be prejudicial, that is what would have to happen, that would be a surprise, and that is something that came at the 11th hour.
Just so I understand, though, was the statement by Mr. Collins, that was turned over right before the trial started to the defense, or had the defense had that for a while?
No, ma'am, that statement was
They had it.
originally given over in
Right.
discovery 3.5 years prior. It predated, I believe, I'm going to walk a fine line, and if I reference something that isn't in the record, I apologize.
Yeah.
It is my understanding that both were interviewed prior to the indictments being handed down, and I believe that one of the reasons why the state wasn't anticipating calling Mr. Collins is because he was incarcerated elsewhere.
Right.
And that made him unavailable for us, and you know, the state felt unnecessary because kept thinking that it was going to happen, and it was going to happen, and you know, part of the court's, I believe, I wish the court didn't express frustration, but I believe the court expressed frustration. I think that's evident in the record, was the dilatory tactics with malingering in terms of the competency issue, the clothing issue, the unwillingness to cooperate with counsel, and that the court viewed this as just another delaying tactic. And so I think that goes towards the willfulness and bad faith, the third criteria, Papadakis. And so I think that from the criteria that can truly be evaluated absent the proffer, the court found that there was surprise. The court, from the totality of what the court and the discussion about it, we can find that the court found surprise and willfulness. And the other 2 criteria, I believe, require the proffer in order to be fully explored. In the absence of that, even if the court did abuse its discretion in excluding any error or any harm suffered by Mr. Prather, is purely speculative. And on the record before the court, the testimony would have been inculpatory. The only proffer that we have truly is that the statements would implicate Mr. Prather, and therefore I don't believe that prejudice can be demonstrated. That was a lot more than I intended.
You did well, you hit 11 minutes.
If the court has no questions.
Oh,
Thank you.
Thank you. Mr. Hoffman, you have about 5.5 minutes left.
With regard to the court's question about the trial court's inquiry, there were findings or lack thereof. Counsel never indicated that Mr. Prather learned of Mr. Collins' willingness or offer to testify on his behalf at the point of his release from prison. Counsel just said he had been released from prison 2 to 3 months prior to the trial, and that was it, and that she was contacted by her client over the weekend before the trial started about his availability. There's no indication that Prather knew of Collins' willingness to testify on his behalf as soon as he was released from prison.
But it seems like that's like a point that defense counsel would be making to establish the propriety of allowing this individual to testify, to say like, look, Your Honor, he got out of prison 2 months ago. We've made diligent efforts to try to find him. We just, established contact with him and learned that he's willing to testify. I mean, that starts to make the record, getting to Mr. Donovan's points, like that starts to make the record of diligence better for the defense. I mean, I hear what you're saying, but trial counsel didn't really lay that groundwork.
It's true. One other thing, though, I want to mention is that the second syllabus in Papadales puts the onus on the trial court to inquire about these things. It doesn't put the onus, and the same is true with a proffer. I mean, it's a mistake not to proffer, I admit that. But the duty is on the part of the trial court to inquire. I mean, findings aren't required, but the inquiry is. And all 4 points they're supposed to ask about. And it didn't happen here.
So you're saying the trial court specifically needed to ask defense counsel what impact the exclusion of the witness would have on the trial?
Exactly. That's right from the syllabus.
So you're saying this is not counsel's fault for failure to proffer, but it's the trial judge's fault for not asking the question?
Exactly.
Okay,
So with that, I'd ask that the court reverse. Thank you.
thank you. Thank you both for your arguments this morning. We'll take the case under submission and issue a timely decision. And that concludes court for this morning. Thank you both very much. Have a good day.